All right, this is the 8th supervised visitation. Today's date, 10 October 2023. Just like I said in the rally, this is about black babies. For those of you who are watching, you want to understand why black children are growing up in broken systems. They're taking their daddies away from them in this system, okay? Now, the detective here is Detective Giordani. The new list that the jail has out for her witness list, this detective is not on that list, the same as the police officers. It's very key. Her only witness is the scorned ex-friend, Joanne Thomas, that had my children taken away. Okay, end of supervised visitation for November the 19th, 2023. Very, very important attachments. They're excerpts, all right? These audios are my recordings, like I said at the rally, of me recording myself and or Angela Morehouse inside the courtroom. The audio attached is me getting a leave of court. After that audio, you're going to specifically hear Angela Morehouse talk about me not getting a leave of court. The question to any and all of you involved, whether it's the Attorney General's office, whether it's the governor's office, why is this lawyer lying on this recording? That's one of many that are going to be following before I set foot in that courtroom. And again, if you're following this story, this is myself holding my daughter. This is Detective Giordani. There's also going to be a list attached to the end of this of the new witness list. Not one single police officer. That includes the police officer on the FOIA video and the 911 police officer that came to the home of the pedophile. And this is Detective Giordani. He was never ever questioned by Angela Morehouse, and specifically by my lawyer, Aaron Barr, who knows Angela Morehouse, when he came to court and testified. The recording you guys are hearing on this audio pic is crucial. My daughter was 3 years old at the time. My son was 5. They were forced to say certain things about me touching my biological daughter, okay? Angela Morehouse is aware that my children were talked to Judge Wellington, who gave the supervised visitation for her mother, for Sabrina Harris. Angela Morehouse was forced to do supervised visitations with herself and the kids' mom for hitting them. That's what this has been about. It's a hunt, if you will. And this has been a hunt for her. But at the end of the day, the roles have reversed. Follow this story. It is going to be the biggest story in the United States because of what lawyers and judges are doing behind our doors. Thank you so much. Please continue to protect the babies. Please listen to the audios attached. Thank you. Yes, ma'am.
I'm going to issue the preliminary protective order based on your affidavit. Both kids are going to be listed on this, sir.
Yes, ma'am.
For the full hearing with the children, June 13th at 1:30. I'm also going to appoint a GAL. I'm going to appoint Ms. Keeler, and we've given you a copy of her name and number, okay? She'll assist you and the children on this, okay?
Oh, and also, ma'am, I was being told by my attorney to let you know to inform you of a leave of court for me filing this. I'm supposed to let you know about that.
I'm sorry, you need what?
A leave of court to file a protective order.
This is the preliminary protective order, and I'm setting it for a protective order hearing, so I'm not sure what your attorney's talking about, okay?
Okay, I'm just telling you what she said to
okay.
me.
Yeah.
Miss Baird, no disrespect, I don't know if I'm supposed to ask you a question, but do you remember talking to me? I was in Loudoun County Adult Detention Center. I was acquitted of my charges, but you was on the phone with me. Do you recall that conversation?
No, sir, I don't, and I didn't go to Loudon any at all. So.
No, it was a telephonic communication. I remember the name, that's all.
Okay, maybe it was someone else. All right, thank you.
All right, thank you, ma'am. I appreciate it. June, I'm sorry, what was it, June what? June?
No.
June 13th at 13:30.
Yeah, and the advocate.
Okay, thank you very much for your time. Thank you so much.
I'm not trying to sound like, they're probably
Interpreter needed, you can have two. All parties involved in the Reynolds matters, JDR 4, Reynolds, JDR 4.
Excuse me, I'm sorry about you guys. I gotta get back to work. So she told me that you're the ex-person. You got my information?
Yeah. It's in the card,
okay.
but
they gave me a court date for the 13th of June. So you need to contact me.
Yeah, here's my information.
Right.
And then we can just speak on the phone.
Okay, all right, thank you. Sorry. All right, thank you.
That talks about any motions, petitions, or other court requests, including but not limited to, and it goes on to cite other things, in this case, any court proceedings whatsoever. So, Mr. Harris has put on notice back in 2020 that this was something that we required to leave the court. A simple motion would have done it, but he declined to do that and chose to seek redress in a different way. We asked the court to find that the patrolling order in this case is one signed by Judge Wellington on March 16, 2020, and dismiss the petition based on that fact.
Well, I see where Judge Barrett signed the ex parte preliminary protective order, but I don't see any notes or anything of that nature to indicate that it was even brought to her attention that leave of court was granted or anything of that nature. I'm sure she would have maybe noted that. That being the condition of the preliminary protective order, she would have made a note that she found that to be the case, but it was granted. I don't see it.
Your Honor, may I briefly confer with my client? I believe he has some information on his phone that may be helpful to the court in settling this issue.
I don't. Miss Morehouse, what else do you have?
Yes, Your Honor, I was just going to bring the court's attention to the fact that there is a right way to file a court leave of court and a wrong way, and I know Mr. Harris knows the right way because we were here quite literally yesterday in this court in front of Judge Lucas, who is the ongoing judge who is hearing matters for these children, in which case he filed a written motion for leave of court to file a rule to show cause against the mother, and in which the court granted leave of court, and in which we proceeded appropriately and accordingly. That was not done in this case, and furthering the problem to me as the guardian ad litem for my wards, that father then proceeded to subpoena them here, despite the fact that we have court orders prohibiting ongoing litigation because of what father has filed. Now, not only has he done so, but he's involved my wards directly as well, bringing them here pursuant to subpoena and asking the court to dismiss this rather than continuing to cause stress, difficulty, and confusion in their lives.
Counsel, I don't see anything here where he filed a request of leave of court whatsoever. The order of 5/10/19 is very clear. And also the order that Judge Wellington entered back in prior to that. So,
Your Honor, my understanding from my client is that Judge Barrett orally informed her that she wanted to hear this matter, that he did disclose it to Judge Barrett. I understand that the file may not have any notation regarding this order in there. What I would suggest that we could do is possibly contact her or chambers to find out if we can resolve this matter if it was raised.
I'm subbing for her today, so she's not here.
Suggest if it really had been raised, it would seem likely that it would have been placed on the docket of the judge who had been hearing all of these matters, which is Judge Lucas, which would have been the ideal way as well to proceed, but was not done.
Right, I mean, filing, as the guardian has stated, he's already filed leave for the, for his requested, what, visitation or custody issue?
A rule to show cause against mother, which was dismissed yesterday at the motion to strike face, frankly, and there is also underlying motion to modify visitation filed by mother. That is proceeding, but within the context of what he filed, it was done correct. It was done in a written motion format.
Right, and he did request leave of court at that time.
Correct, for that specific filing. Also, to the extent if it matters in this conversation, we recently had a custody hearing in February and March of this year upstairs in the circuit court, and I have a copy certified of that order as well, where that court made additional findings of father's ongoing false claims of abuse to Child Protective Services, and that father continues to believe mother is putting the children in harm's way. His belief is not supported by the evidence. This was as recently as March of 2022 after a 2-day trial before the circuit court. This is an ongoing pattern of allegations that father makes that is problematic and has not been supported.
Your Honor, if I may respond.
You may, but I mean, clearly your client was aware that he needed to make the court aware of that to file a written mode before he even asked for the preliminary protective order. He was here at the preliminary protective order stage, but he hadn't asked for leave of court to file that.
Your Honor, what I would proffer to the court is my understanding is my client did inform the court of this prior order and part of the ex parte proceeding. I understand again that the file is silent one way or another about that matter. What I would ask the court to do is rather than consider dismissing this case, allow it to be continued for Judge Barrett to come back and ultimately rule on this matter based on her recollection. Alternatively, Your Honor, for leave to amend to allow for leave of court, especially because the allegations are coming from the children themselves, not from father. He is acting as an ex-friend, but ultimately the children are the ones who are the witnesses to the abuse and who we're seeking the protective order for.
Let me ask the guardian, have you investigated these allegations?
I have, Your Honor. I've spoken with the children. I'm very confident about what I anticipate the testimony would come in to be, and that it would not be sufficient to rise to the level of a protective order. I will also tell the court that this is exactly father's pattern of behavior, is bringing the children to the police station and having them make certain statements, which upon subsequent investigation are determined to be unfounded, and that has happened repeatedly. That is part of what the litigation in this court and in the circuit court and in the repeated hearings has been that led to the order of this court in 2020 prohibiting precisely this.
All right, I don't see any proof in this file at all of violence. I mean, the first thing I should have seen should have been a request for leave of court and an order, and it wasn't there, so I will